Morning. May it please the Court. Philip Greenwald for the appellant. Your Honors, I'd like to reserve 5 minutes for rebuttal, if I may. The issue on appeal is whether or not there was substantial competent evidence to support the 6-month limitation that ACCA placed on the variance or waiver that they had granted to Alex Greenwald in connection with the allowance of behavior service, assistant service hours. It's the position of the appellant that there was no substantial competent evidence to support this, and asks that this Court vacate the limitation on the variance.
So there was an emergency waiver granted, I guess in late 2015, and it expired in March 2016.
That's correct.
What happened after that? Have there been any additional variances provided?
Yes. At the point that the emergency, a month before it was to expire, a petition was filed on a non-emergent basis to tie into the expiration date. That is the petition that is the subject of this appeal.
And it wasn't so since March 2016. You've been limited to the 32 quarters, I think it is, 8 hours.
That existed for about a 6-month period. The petition was denied in toto initially by ACCA. The petition to extend the temporary variance beyond March 29th of 2016 was denied. An administrative hearing, an informal hearing was requested. On the eve of that hearing, ACCA reversed itself with respect to a total denial of that petition, and instead at that point, I believe September 29th, granted the variance again, or variance or waiver, I'll refer to as a variance if that's all right with your Honors. However, limited it to a 6-month period of time.
Okay, so that 6 months has run. What's the situation since the end of the 6 months?
Yes.
That's outside the record, though, isn't it?
Well, it's technically outside the record, although I noticed that ACCA filed with their appendix a copy of the order of stay granting a continuation until this appeal resolves matters.
And each 6-month variance, does that involve a tapering down? I think the words were it starts with, I'm sorry, how many additional hours does it start with?
The variance is really tied into the number of hours that have been approved by the local review committee of the Agency for Persons with Disabilities. The variance itself does not specify how long the hours should exist or what tapering down should exist. It simply states that the 6 months will allow for a time-based fading of services, presumably with the anticipation that at the end of that 6 months there will no longer be a hardship and there will no longer be a medical need for those additional hours.
I'm not familiar with this area of law, so I want to make sure I'm processing correctly. And I think what I'm understanding from reading the briefs is the concept of a behavior assistant is to teach the primary purpose is to teach caretakers how to manage the behavior of someone who's developmentally disabled.
That's correct.
And so the concept is, as Judge Force alluded to, that over time the caretakers will, through the education process, enhance their ability to deal with the behavior such that the actual professional services by the behavior assistant would diminish over time.
Correct.
Okay.
Correct.
So looking at the language in the handbook under the section dealing with behavior assistant services, limitations and exclusion, when I'm reading that, it leaves me with the impression that the handbook is saying that if additional services are needed after a 6-month period, a new request or petition can be made. So are you saying that once they came back and in the middle of this whole petition process made some amendments to the rules or the handbook, that's not the case? And if it is, I guess what I'm asking, similar to Judge Forrest, is if the handbook provides for the opportunity to keep requesting additional 6-month periods of waivers, how is your client being harmed is what I'm trying to figure out.
Okay, first, these requests are not petitions being made to ACA. These requests are made to the local review committee of the Agency for Persons with Disability. The APD and the LRC are involved in designing and implementing the plan, which includes, in this case, the record shows, fading of services upon reaching certain events. There is nothing prejudicing my client with respect to the 6-month limitation, except that it doesn't allow the process which is contemplated by the handbook, which is doesn't allow the qualified people who work on behalf of Alex to approach the local review committee, submit the necessary records, and continue without interruption the behavior assistance services. It does not contemplate ACA weighing in on that at all. And the handbook does not set forth any specific time limitation. So there's a severe prejudice in stating, where it's nowhere stated in the handbook, that services are to end at a certain point and can only continue with a variance.
So you're saying you don't, because of the circumstances here, you don't need to keep reapplying for the extensions, that the people on the ground should be able to just recommend it and it should be implemented without the request?
Well,
without a formal request?
Correct. The object of the petition, under ordinary circumstances where you don't need the variance, you still have to go to the local review committee if the number of behavior assistance services exceed 24 quarter-hour units a day. And if you continue to be at a certain level, even without a variance, you're still required to go and submit documentation every 6 months to continue the authorization to have LRC determine if the need is still there and authorize that. This has no involvement, no requirement of variance. The only thing that required the variance in this case is the fact that there's this limitation placed that if you exceed the 32 quarter hours, well, you could not exceed that. And so it was now out of the hands of APD.
But couldn't you, again, request again that they extend that variance? And is the problem that
Request
the
from
amount
ACA?
of, from ACA, is the problem that there's some delay in the processing period, that there could be a gap where your client's not going to get the services? Is that what the problem is?
I think it is. I think it is a significant procedural problem, and I point this out in my initial brief. As a practical matter, with the temporary variance, the emergency variance that was applied for, ACA is allowed 30 days in order to act on that. They take 30 days to act on that. With a non-emergent petition, they take 90 days, which they're entitled to take. And in this case...
So are you prohibited, if you're anticipating that you're going to need something beyond the 6 months, is there something that precludes you 3 months in to go ahead and file another petition because you're anticipating another 6 months down the road?
No, the conundrum created by that is this, that at the 3-month point, when ACA has stated in the variance that by the end of 6 months you should be below the 32 quarter hours, they've made this prediction. So now there's a burden on Alex to, 3 months into that 6 months, to say 3 months from now I'll be at that point. I'm not at that point now. 3 months from now I won't be at that point. It's very easy for ACA to say it's very speculative that you're going to need this 3 months from now when they've given you 6 months.
Why not file it as an emergency if that's the situation?
And I don't think the system was designed for that, but we could file that as an emergency. Again,
But that only buys you a month, is what you're saying.
then you'd have a month hiatus of services, and you'd have to again engage in this petition process that was already undertaken. The object of the petition that was originally filed on a non-emergent basis was to say, let's recognize what's going on here. Alex is a unique individual, one of only 4 individuals in the state who exceed the 32 quarter hour requirement as of the time you promulgated it. The hardship isn't going to go away in a short period of time. The record evidence shows that for the near future, it's not going to go away. He can gradually reduce hours, but not on a 6-month timetable. And there shouldn't be a need for us to have repeated petitions in order to obtain what makes sense here, which is let the agency that does this work, APD, through its local review committee, continue to monitor this, as they do on a monthly basis at this point, to see if he continues to need to have the benefit of the variance. Allow them to determine the number of hours he needs, because that's their job. That's not ACA's job.
But isn't, it just strikes me that the practical problem presented by this case is, to what extent are there any experts in this area that can make a projection based on the level at which Alex is performing now, and looking at the short past history of what the behavior has been, can we project how long he's going to need more than these 32 hours services? And do we, isn't that really what it boils down to?
It is, and that's why you have a panel of experts, behavior analysts, who on a monthly basis review his plan, determine how many hours he needs, and if it's still justified.
So, but when they determine that, though, are they just determining what he's going to need for the next month, or are they projecting, how far out are they going, saying he's going to need this for a period of time? How far out can they go?
Well, the record shows the behavior intervention plan and behavior service requests, and those obviously indicate that he's going to need these services for a long period of time. But the function...
Long period of time, doesn't say 6 months, a
Correct.
year. Just,
but what the LRC does is it tracks its progress. There's statistics, there's data gathered to determine whether or not the need is still there. They're in the best position to monitor this and revise this and say, we're not going to honor the behavior service request because he no longer needs that. He's on a downward trend. We can reduce it, we can fade it, we can cut it back. And that is their work. That is what they do.
Who
Now,
came up with the 32-hour determination? Is that ACA or is that the local?
That's ACA's promulgated manual.
That's their baseline?
That's their limitation. It's like an insurance policy. These are the covered services, behavior assistance services being among them, and this is this is what's allowed for behavior assistance services. I think, though, if I may, Your Honor, a very important point here is that the statute regarding variances puts the burden on ACA, if they're going to limit it, to have record evidence to limit it. Now, record evidence is not the fact that Alex has to submit paperwork to have this on an ongoing basis. Record evidence isn't made by that. There's nothing in the manual, there's nothing in the statutes that dictate that at the end of 6 months, a variance cannot be given. And that's the condition that they've imposed on it.
So your primary contention is there's no competent substantial evidence that ACA has put forward at the hearing that would justify lowering the services.
Would justify the limitation on the variance under 120.542.
6 month limitation.
Excuse me?
The 6 month limitation.
The 6 month limitation. Once they grant it, once you meet the two-pronged test of 120.542, then you can only limit it to the extent necessary to achieve the purpose of the statute. And this they haven't shown. There was nothing in the order. There's nothing in the record supporting the 6 month. There's no reasoning in the order. It just kind of came out of nowhere. And they've tried to, come up with some information.
Well, you say it came out of nowhere. It came out of the handbook, which the regulations require them to
Somewhere
follow.
somewhere in the handbook it said every 6 months you have to seek reauthorization. That's not probative of the fact that after 6 months Alex will no longer need services. And that's what they're saying, that the request was he needs these services, it's a hardship, he meets the test of hardship, he meets the test of satisfying the purpose of the underlying statute, and if you want to cut it off, you've got to show that this is in furtherance of that statute, and somewhere it says that no, that's all going to disappear after 6 months, and there's no evidence of that.
So are you wanting us to basically come out with an opinion that says to ACA, if you grant the extension, you have to grant it until the other group that designs the care plan or whatever says it's no longer needed? In other words, ACA is not allowed. You want us to come out with an opinion that says, ACA, you can't put a time limit on it other than the committee says he doesn't need that level of service anymore. That's what you want us to
Yes.
come out with an
And I
opinion that
believe
says that.
I believe pursuant to 120.542, that is the appropriate manner in which to deal with this. Now, ACA has
But
sidestepped.
there's no cases that specifically
There
have
are
done
not.
that.
There are not. There are very few cases that have been decided under 120.542. And I see that I'm running out of time for rebuttal.
Okay. I'll give you some extra time after we hear
Thank you, Your
from
Honor.
Martha.
May it please the court, my name is Tracy George and I represent the Agency for Healthcare Administration, or ACA, the appellee in this matter. Appellant's situation is one that evokes great sympathy, and we realize that. But the issue for resolution, as Mr. Greenwald stated, is whether or not we granted the variance or waiver and the conditions on the variance or waiver in accordance with the statute. And we believe that we've done that in this case. The purpose of the statute is 393.0662, and the companion statute, which is .0661, is to authorize ACA and APD together, which we did, to come up with rules for this I-budget waiver and the developmental disabilities waiver. And that includes coverage limitations on services. Services have to be more than just medically necessary. They have to also be covered within the limitations set. Those limitations are in the I-budget waiver handbook, which has been adopted by both agencies at this point. APD has always been required to apply it. At the time that the petition was requested in this case, and when the temporary one was requested earlier, APD had not actually applied it to this individual's services request. And that's why we wanted that to occur. We wanted APD to have a chance to do that and to figure out what exactly he actually needs under the current definition of the services, which relates to training of the parents and the caregivers. We don't believe that the family is receiving perhaps services that meet their needs. They might need something else other than training services to assist with the care of Alex in this case.
Does ACA, the 32 hours, ACA has agreed that that's, and I guess that's generally the max other than 4 situations, but is there any circumstance where the 32 hours would be reduced? And how would that happen?
I'm sorry, Your Honor. I think I'm not sure I understand the question. The 32 hours is the limitation on services.
Okay,
He's getting more than that.
Right, but he's getting more than that under a variance that expires every 6 months.
And he can request I think one of the problems that this court was having is if there's a variance or waiver requested and it takes ACA a while to rule on that, what happens to his services in the meantime? And my suggestion would be that he could request a stay of the current variance or waiver until ACA rules on the next one.
Okay, but
Have they done that already?
Is there a procedure? Is there something under your procedural mechanism that allows that?
I believe that he could file something with the agency clerk at ACA and that we would look at that. And if that's not granted, then, I think that ought to be filed at the same time as the petition for variance or waiver. But if it's not granted, then obviously that would be a problem. But I think that we would do that.
Do you agree that practically speaking, if they tried to file a petition for another 6 months, 3 months into the existing one, that's going to be viewed by ACA as being speculative and all that?
Well, what we need to look at is what's being approved at that time and what APD and his behavioral assistants and behavioral analysts are saying. And, there'll be a factual hearing 3 months in. If it's denied, there'll be a factual hearing.
Well, let me clarify something else that you mentioned, if I heard correctly, and that is that ACA has concern that perhaps Alex is not getting the right services. My question is, what state agency or agencies, who makes that call you know,
As to what the services should be.
rather than behavior assistance, you need this instead. Who
Well,
makes that call?
It's kind of the handbook has been adopted by both the agencies. The handbook explains what the different services are that are available under the
And it will
handbook.
just be the two agencies, ACA and
And APD actually
APD.
does most of the looking. at
Children and
things.
Families is not involved in any of this. No other state agency is going to be involved in it. It's just those two?
He may have services under another agency, or he may have another agency involved in his care, but with regard to these waiver services under the Medicaid program, these are the only two agencies involved.
And so is it, so do I understand, the two agencies were charged with coming up with the rules and the guidelines and, you know, developing the handbook or whatever, but are you also supposed to collaboratively come to a decision about what actual services are best for this client?
APD is supposed to determine that with the help of a support coordinator who is assigned to this individual, who's supposed to help figure out what supports are best. Now, keeping in mind, in this particular situation, we've got an individual who is coming out of a rehab center or a center, a rehabilitation.
A residential
You call it,
facility.
residential center. And so he's transitioning back into his home. So obviously he needed more services to start with to train everybody. And now we're into however many months that is past that, his caregivers should be being trained. He was, at the time, both of these variances or waivers that were requested, he was receiving services at his adult day training center. Under the handbook, actually, he's not supposed to be getting those at all. They're not supposed to be getting services at ADT, so that's 7.5 hours a day that it ought to go down. There's also, he can have a personal care services provider who could be trained to help provide some of these services, who would do assist with daily living skills and things like that. So we're just concerned that APD, as of the time of this petition for variance or waiver, had not assessed him under the current handbook. They'd assessed him under the rules that had happened before that. And so we wanted to say, hey, at the end of this 6 months, which is the period that you must be reassessed with under the handbook, we'll look at this again.
But is there a tapering down during those 6 months?
The tapering down is required by the handbook also. It says in the handbook that that you must have a time-based fading of services. And keeping in mind that appellant here has never requested a variance or waiver from anything in the handbook other than just that requirement of the 32 quarter hours. So everything else applies. Everything else applies under the current variance or waiver. He should be not receiving those services during ADT. He should not be receiving services that don't meet the description for of the service in particular for the training. This is not supposed to be a situation where the trainer is supposed to be doing hands-on interventions indefinitely. They're supposed to be training the caregivers. The caregivers are supposed to be learning how to do those things to assist, and then the services are supposed to be backed off accordingly.
The training is supposed to be
Yes,
backed
the
off.
training's supposed to be backed up accordingly until maybe AG needs to learn something new, and then they can ask for more. The support coordinator and APD can approve more services, and then those will be tapered down too. So it's supposed to be it's a training mechanism. It's not a caregiving mechanism.
What about the argument that we've heard that the 6 month waiver is arbitrary based upon this person's needs?
I don't think it's arbitrary because it specifically says in the handbook that if you want services for more than 6 months, you have to resubmit all this information. And
You're saying it's not arbitrary because it applies to everybody across the board?
Yes.
But address the argument that under the statute, you should not be allowed to put a time limit on, other than the care coordinating group or whatever makes a decision that level of service is not needed anymore.
And I understand what his point is with that, but you have to keep in mind he didn't request a variance or waiver from anything other than those 32 quarter-hour requirements, okay? And
So you're saying there's a preservation issue? is basically your
Well,
argument.
basically asking that the services be approved as long as they're medically necessary. And all the provisions in the handbook together say, here are all the reasons why, all the ways in which services may be limited, the coverage of services may be limited. And so he's asking for medical necessity and the limitations on coverage apply, not just medical necessity. So what he's essentially asking for is that he can continue to receive these services at 32 quarter hours until they're not medically necessary. That's what he asked for in his petition. And that's not the only requirement. It's also that he has to comply with all these other provisions of the handbook. So the waiver that he asked for is not the one that he really wants. And it's not the one that we're willing to grant on this petition. As a matter of fact, this court, and it can't really order ACA to grant it either, because under 120.54 sub 1, it says, I'm sorry, yeah, you have to actually ask for something. It's 542.5a, and also the rule. The petition must specify the rule or portion you're requesting a variance or waiver from. So he needed to really ask for something more broadly, and he can do that. He can do that today. He can do that tomorrow. This is not a situation where we're saying he can't have a variance or waiver. We're saying we're not going to grant you what you didn't ask for.
Is there a point, or does ACA have the authority to say, we agree that this amount of behavioral assistant is necessary in a residential setting, but that's more than we can handle, and therefore force the person into a treatment center?
Your Honor, we don't ever want to force someone into a situation that they don't want to be in. He needs to have services, and APD will decide what those services should be with the help of the support coordinators and the local review committee and his services providers and all that. All ACA is saying here is that you're not complying with other portions of the handbook. We want you to come back at the end of 6 months and see where things are.
So this is ACA's position is this is just a process
Yes.
dispute?
And the problem is that, unfortunately, they're requesting services at a time when the program is changing. Okay, so this isn't how the program was. This is how the program is now. So that's the whole reason the variance or waiver was requested to begin with, was because under the old rules, there wasn't a limit on quarter hours. This particular service description didn't apply. The requirement of the time-based fading was not in a handbook. The handbook didn't exist. This handbook came into effect. They asked for a variance or waiver from that one provision in the handbook because they realized that that's one that was kind of a real problem for them. And then, we granted that for 6 months. Then we came back and denied it when they asked for it again, because everyone has to comply with these. He was only affected differently from other people under the handbook provision because of the amount of services he was receiving to begin with. Okay, we realize his condition is what it is, but that limitation applies to everyone. And so basically, the purpose of the rule is to force everyone to kind of figure out what services are best and try to provide a less costly service. And that's what the legislature's charged us with, is kind of being the bad guy in these situations. It's not a fun position, but it's what the agency is charged with doing.
He's asking for a baseline, or a variance. What's the baseline?
What's he receiving currently, or what was he receiving at the time?
Did ACA say you get this amount of hours, but you can ask for a 6-month variance for additional hours?
He was receiving, I believe it was, I think it was 70 hours a week, which is an equivalent of 10 hours a day, and the handbook allows for 8 hours a day. No, he's receiving 70 hours at home, and I think he was receiving another 7.5 hours at adult day training. So he was receiving an equivalent of 17 and a half hours a day if you average it all out, which is a lot of services, and the handbook only allows 8. So what we're trying to do is kind of force him to figure out how to train those caregivers. And then when he needs more services because they're implementing a new skill or whatever, if it comes up over that 32-hour mark, or that 32-quarter-hour mark, then of course he can ask for another variance or waiver. But this is how the program works. That's how it works. If no one has any other questions, I'll rest on our brief.
Yes, sir, I'll give you a couple, at least 3 minutes. I'll give you 3 minutes.
Your Honor, to listen to ACA here today, you would think that it was APD talking, because ACA has no business in determining what might best suit Alex. This is specifically under 393.0662. APD is charged with creating the I budget, or the total amount of money that Alex is deserving based upon his needs. And APD is charged with designing and implementing behavior service plans. And they have been under a prior handbook of 2010, and they have been under rules that are not materially different than the ones that have been raised in the answer brief, and I would stand on my reply brief with respect to those aspects. And this court does have the authority to vacate the limitation that has been put on the variance without any record support. And I think ACA is trying to suggest that the record support for variance is the fact that the regulation in the handbook that says that you need to apply every 6 months for reauthorization. That application is, if you look at it, it's not a full application. It's behavior assistant submitting documentation to the local review committee to document the need, the ongoing need, and the failure to do so by default is you lose the services. But you simply have to provide documentation of what's been going on. That's in the handbook that has been cited, and that is the appendix to the appellate brief.
APD doesn't get the final say, correct? They
do.
They make the
They get the final
recommendation.
care plan, but I mean, there's still the budgetary limitation about how the dollars.
Under three, well, there is obviously a finite amount of money.
Right.
Under 393.0662, APD is charged with establishing the individual budgets and assuring that the total of all the individual budgets do not exceed the total amount of funding. Now, ACA is involved in promulgating rules, but they are not involved in the management of the delivery of these services. One of the difficulties, I think, in this case is, and one of the issues that's been first raised through the briefs, is whether or not, when the statute says that the variance has to serve the purpose of the underlying statute, you may then switch to a different purpose to justify the limitation. What really boils down to ACA's limitation here is they're saying, well, the limitation is necessary for the purpose of statute because it implements the statute. It implements the rules for which a variance is needed. It's just about implementation of eliminating a variance and going by the rules. This is not a one-size-fits-all situation. 393.0662 is entitled Individual Budgets for Delivery of Home and Community-Based Services. The object is to deliver services. The object is not to limit services.
But just if ACA is saying, in essence, we need 6-month updates, so to speak, it seems to me that that's quite reasonable if their responsibility is to try to figure out how to work with APD, develop all these individual budgets that are all going to be within one large budget item. And if you don't periodically get updated information, how are you ever going to be able to manage the system without it?
If ACA wanted to manage this individual budget and wanted to take on the responsibility, which is not theirs, to determine the ongoing need, it would make absolute sense if they put a limitation of the variance that by such and such a date, Alex will submit certain documentation so that we can reevaluate the need, and the variance will be continued until we no longer see the hardship exists.
But basically what you're asking us to do is to rewrite the rules to basically say that. I mean, are we allowed to do that?
Well, this would be a limitation that would be proposed that would be reasonable, as Judge Connor points out, if ACA really wanted to get down in the trenches and do what they don't do, which is determine what the needs are for Alex.
So basically you're advocating for a rule change.
No, I'm not, Your Honor. What I'm advocating, the system, the reason that we didn't request any other variances, we're not asking for any variance other than for the 32-quarter-hour requirement. And the reason for that is the system is set up for monthly reviews by the LRC anyway. The system is set up for APD to make sure that his budget is based upon needs. The system's set up for reviewing all these services and whether he has an ongoing need. Now, the reason for and so we really don't need any limitation. All we need this court to do is to vacate the limitation for which they have no support. The order does not articulate any reasoning behind their limitation. The order only articulates one purpose that's being forwarded, which is that health and safety needs of Alex are going to be met by delivering services that exceed what's in the manual but are within his cost budget. The money's been allocated for him. The object of 393.0662 is to give Alex or people on his behalf to spend things best for his needs. And all we're asking is that variance be allowed. The rest of the system will take care of itself. And instead of going with the only articulated purpose that Alex's needs are met by allowing him to spend the money that's been allocated with him, they have switched in their answer brief to a totally different purpose, which seems to be the purpose of the statute is to enforce the rules. That wasn't articulated in the order, and they tried to cobble together justification for this limitation in furthering that purpose, which is a different purpose than the purpose for which the variance has been given. I don't think the law, you can reasonably read 120.542. The two provisions relating to the purpose of the underlying statute should be, in our view, read together, and they're referring to the same purpose, not different purposes. And I think they've really they have sidestepped all the arguments that are made in the initial brief. They have failed to respond that he will no longer need. In the brief, we set forth that all the record evidence shows that he's going to need the service beyond the 6 months. So the hardship's not going away. The fact that he's been singled out is not going to go away because he's one of 4 people in the state who, because of the implementation of the manual, is now in this position where he's exceeding the number of services.
Okay.
I thank you for the time, Your Honor.
All right, thank you. The last case that was on the calendar today, unfortunately, one of the